Hi everyone, my name is George and I'm the head of the Global Mobility and Immigration Division at Madison Law Firm. I hope you're all well and safe. We're going to start off by asking, is your spouse or de facto partner an Australian citizen, Australian permanent resident, or an eligible New Zealand citizen? If the answer is yes, you may be eligible to move to Australia with them and obtain your permanent residency. This type of visa application is called a partner visa. Many of you may have already heard of it, but there's different types and the subclasses are all very confusing. There's the subclass 820, 801, 309, 100, and even the subclass 300 prospective marriage visa. What do these subclasses mean, and what's the difference between them all? Well, we'll finally put all the confusion to rest. The subclass 820/801 is a combined onshore partner visa. The subclass 309/100 is a combined offshore partner visa. When we say combined, it means that you're essentially lodging one application for two visas, but you may need to lodge another application called a second stage partner visa application, if one visa is granted before the other. We'll elaborate on that a little bit further on in the video. The subclass 300 is the prospective marriage visa, commonly known as the fiancé visa. The subclass 300 is a temporary visa and gives the holder a 9-month visa to enter Australia for the purposes of marrying the sponsor within the visa validity. They must not marry before entering Australia. And the partner visa differs from the prospective marriage visa because you don't necessarily have to be married or intend to marry, but again, we'll circle back to that point a little bit later too. As mentioned before, the partner visa, and that's either the 820/801 if you're in Australia or the 309/100 if you're outside Australia, is called a combined application because it combines the two stages of the visa. The first stage is a temporary component, and the second stage is the permanent component of the visa. So you can apply for a partner visa if you're in Australia via the subclass 820 or outside Australia via the subclass 309. You can also apply for the onshore subclass 820 if you've arrived in Australia on a prospective marriage subclass 300 visa after you marry your sponsor. If 2 years passes from the date of the temporary visa application lodgment and your relationship is genuine and continuing, then you will be eligible for permanent residency at the 24-month mark. We'll begin by explaining the temporary partner visa first. Most temporary visas can be determined between 15 and 24 months. However, this may vary depending on which country you're coming from and whether you're applying whilst being in Australia or outside Australia. You must ensure the application is filled in correctly, and you provide all the required documents so that you don't delay the processing times. While your application is being processed or determined, you may not be allowed to leave Australia if you lodge the visa onshore, unless you apply for and hold a special type of bridging visa. If you apply for the partner visa offshore, you'll need to apply for another visa to travel to Australia whilst the offshore application is being processed. A temporary partner visa, once granted, allows you to remain in Australia until your permanent migration visa is being decided or withdrawn. It allows you to work, study and travel with no restrictions, and it allows you to bring any children that are dependent on you and who are included in the original application. You must apply for the visa online via the online Immiaccount. It requires you to fill out questions about you and your partner or spouse, such as your family, past relationship, past travels, and more. It also requires you to provide supporting documents of your relationship for proof that it is a genuine and continuing relationship. Proving that you have a genuine relationship is vital. This can be done by providing that you and your spouse or partner must both be committed to a shared life together to the exclusion of all others. Your relationship with your partner or spouse must be genuine and continuing. You must live with your partner or spouse and do not live apart on a permanent basis. If you are married, your marriage must be a valid marriage under Australian law. You will also need to provide supporting documents to prove these aspects of your relationship. If you're in a de facto relationship, you must also prove that you have a genuine relationship by proving that you're not married but live together as a couple. You and your partner must both be committed to a shared life together to the exclusion of all others. Your relationship with your partner must be genuine and continuing, and you must live with your partner or do not live apart on a permanent basis. You must not be related by family.
You must prove that your de facto relationship existed at least 12 months prior to applying for this visa, meaning that you and your partner should have been living together for at least 1 year before applying for a temporary partner visa. In order to apply for the temporary partner visa, you're also required to provide the following: that you have a sponsor who is most likely a partner and is an Australian citizen, Australian permanent resident, or an eligible New Zealand citizen. You are 18 years or older, and that you meet the Australian health requirements by undertaking a health examination by a medical officer of the Commonwealth or a panel physician specified by the department in your home country. You will need to meet the Australian character requirements, which will be through the provision of national police certificates or overseas police clearances from countries in which you've resided for 12 months cumulatively in the last 10 years, or by completing a character assessment form. In addition to the above, you must not have any debts owing to the Australian government. The Department of Home Affairs may request you to provide additional supporting documents which they think is necessary for the proof of your relationship, such as financial evidence or evidence which demonstrates the social aspects of your relationship, even the nature of the commitment to one another, and evidence regarding the nature of your household. Please ensure that these are provided as soon as possible to not cause any further delays in the processing. If you are approved, you can remain in Australia until you're granted a permanent visa or until the temporary visa is withdrawn, for example, in the event of a relationship breakdown. Be mindful, the person who sponsors you to apply for a temporary partner visa must be the same person who sponsors you for the permanent visa. You cannot change your sponsors. Now we will explain the second stage, which is the permanent partner migration visa. This is the subclass 801 for those who lodged an onshore application, or the subclass 100 for those who lodged an offshore application. If you haven't already been granted the temporary partner visa, and the processing of your combined partner visa application has exceeded 24 months from the date of lodgment, then you'll be eligible to be granted both the temporary partner visa and the permanent partner visa in the same day. If you already hold the temporary partner visa, then you will need to apply for the permanent visa or the second stage family visa via the online Immiaccount after 24 months has passed since the initial combined application lodgement date. You will not need to pay a further processing fee unless you're in Australia on a subclass 300 prospective marriage visa and applying for an onshore partner visa. You'll have to provide further supporting documents, such as proof that your relationship is genuine and continuing, any changes to your situation, your passport or travel documents, character documents, information from supporting witnesses, and information about dependent children, if any, also your identity documents. Let's give an example of how this would work. If I lodged my combined partner visa application on 15 June 2020, and the processing of this application continued until after 15 June 2022, then I would be eligible to be granted the temporary partner visa and the permanent partner visa when the application is finalised. But if my partner visa was granted 12 months from the date of application lodgement, then I would be granted the temporary visa, and I would need to wait a further 12 months until being eligible to apply for the Stage 2 permanent visa. In some cases where you have been in a long-term relationship, you may be granted a permanent partner visa along with your temporary partner visa. Thank you for watching our video. We hope we've assisted you by providing the necessary information. If you think this visa might be the visa for you, or you wish to obtain further detailed advice, please contact our firm using the details provided with this video. Wishing you all a wonderful day.